Ladies and gentlemen, a very warm good morning to all of you. And I hope in these exceptional circumstances of global pandemic, you are taking maximum measures to keep yourself safe and sound and healthy. Today, I propose to deliberate another important topic, and that is refugee protection in Saarc and Twailers and refugees in the global South and South Asian approach to international refugee law. This is going to be our brief. Under this particular engagement, my dear friends, we are going to deliberate refugee population and forced migration in South Asia, refugee voices in South Asia, international refugee law, power and refugee identities, and what has been and what is the South Asian state practices in accommodating refugees. It is further going to be supplemented by the Twail approach to international refugee law. We are going to deliberate upon the appropriateness of the 1951 refugee regime, particularly in the context of South Asia or the Saarc grouping. We are going to appreciate the geostrategic manipulation of refugees in South Asia. And further, we have to explore the refugee regime while evaluating the feasibility of the regionalization of the 1951 Refugee Convention and what has been the Saarc response to existing international refugee regime in addressing refugee issues in the Saarc region. Further, we have to undertake the nuances and the niceties which are involved in Asian approaches to present refugee regime, refugees in the global South, and we have to appreciate on a critical footing what exactly is the status of life of refugees, particularly when they are living in refugee camps, and how they have been treated or are being treated in protracted situations, and to what extent the feasibility of the durable solutions or the practicability of the durable solution is available to them. And we have to further, go for refugee narratives as testing the boundaries of the Westphalian model of refugee protection. Thereafter, on the basis of certain important relevant questions, we have to evaluate the entire application of international refugee law or the application of the 1951 Refugee Convention in the context of South Asia. Whenever applications have been advocated, whenever a case has been made for the application of 1951 Convention, in our part of the world, that is South Asia, that has given rise to certain specific questions. Questions like, is there any South Asian discourse or approach to contemporary refugee regime? Why South Asian countries, except of course Afghanistan, have not signed the 1951 Refugee Convention? What are the arguments for and against encampment of refugees and what actors favor which particular argument. How do we assess life in refugee camps from the perspectives of the human security and capabilities? That has to be taken into account. There are other important questions as well, Mr. Ahtashan. What are specific needs and vulnerabilities of the women and children, as they have been addressed as one of the most important vulnerable groups, not only in South Asia, but everywhere? What durable solutions are discussed, and how do we assess these solutions from normative and practical perspectives? Does existing international refugee law, my dear friends, address refugee issues in South Asian region? That is the most important question which requires our immediate attention. We have to identify the bottlenecks in formulating a South Asian or the Saarc approach to international refugee law. And further, we have to explore the feasibility of progressive development and codification of international refugee law under the Saarc mechanism. We must appreciate of the benefits of the uniform refugee law for entire subcontinental region, and that is the Saarc region. And this is how we can further, evaluate the entire mechanism for the protection of refugees. And therefore, my dear friends, it becomes extremely relevant to understand the regional approaches to refugee protection. Every region of the world has developed some kind of a mechanism for the protection of refugees in addition to international refugee protection framework. How we are going to develop this particular mechanism, which is exclusively applicable to Saarc countries? My dear friends, the basic concepts and the principles of international refugee regime, such as the mandate of the United Nations High Commissioner for Refugees, the principle of non-refoulement, and the UN Refugee Convention and Protocol are universal, and there is no doubt about it. They have been supplemented, or rather I should say complemented in some parts of the world with regional arrangements, both to better implement the universal obligations and also to meet the varying needs at the regional or sub-regional level. We have to, on the basis of the experiences of other regions, whether it is Africa, Latin America, or Europe, or Pax Americana, or North, America, that consists of the two nations, that is United States of America and Canada. So on the basis of these, regions and their experiences, we should try to understand one particular, question: why no regional approach exists in South Asia? Because these regions of the world have developed some kind of an approach for protecting refugees. But unfortunately, we do not have any kind of an approach which is exclusive and exclusively applicable to our part of the world, that is South Asia. In many instances, my dear friends, regional approaches have been an important means of strengthening refugee protection as well as finding solutions to refugee problems. Taking into account both the opportunities as well as the constraints which exist at the regional level, but which may not be fully appreciated or relevant at the global level. Countries in Africa, Europe, and Central America have both acceded to international instruments and also developed regional treaties or other declarations to meet specific concerns germane to their regions. The countries of the Southeast Asia have, like those in South Asia, largely avoided accession to 1951 Refugee Convention with its additional protocol of 1967. But nevertheless, my dear friends, took a regional and multilateral approach to resolve the long-standing problem of Indo-Chinese refugees. The most recent effort at adopting a regional approach was undertaken by the Commonwealth of Independent States in the context of a conference in 1996 on refugees, migrants, and displaced persons, under the auspices of the United Nations High Commissioner for Refugees. More specifically, my dear friends, these various approaches can be described in a multiple manner. Multiple manner means, let us take up the legally binding instruments first. Thereafter, we should try to appreciate on the critical footing the operational arrangements. And thereafter, we would also be taking up what exactly should be the contours of the South Asian approach for protecting refugees in our part of the world. Legally binding instruments approach, which have adopted a regional approach, include, my dear friends, Organization of African Unity Convention governing the specific aspects of the refugee problems in Africa. And in case of Europe, the Schengen and the Dublin agreements of 1985 as well as 1990 respectively. Both treaties were sponsored by regional organizations. In one case, my dear friends, Organization of African Unity, and in other regions, particularly that is Europe, rather I should say the European Union, and both were made possible by strong political consensus on them. As I have been advocating, the Refugee Convention, whether it is the 1951 Convention or its additional protocol of 1967, my dear friends, both these instruments were the result of the political will of the European nation states. And subsequently, in 1967, it was the political will of the entire community of nation states which resulted in the adoption of this particular arrangement, which is today known as 1967 Additional Protocol to 1951 UN Convention on Refugees. Recently, we have also witnessed another important development in the history of the refugee protection, and that is the adoption of 2016 New York Declaration on Refugees and Migrants under the auspices of the United Nations Organization, where the UNHCR has been in constant consultation with the national governments, but it was primarily the political will of the nation states that resulted in the adoption of this particular declaration, which ultimately paved the way for adopting two global compacts in the month of December in 2018. Therefore, if we take into account the experiences of the nation states in adopting an approach, a region-specific approach, as we have started deliberating what could be the possible South Asian approach to refugee protection, then the political will constitute a very, very important element of this approach. For example, in the case of Africa, OAU conventions seeks to broaden the definition of refugee to include those fleeing apartheid, decolonization, and generalized violence. It also emphasizes, my dear friends, that voluntary repatriation as an important solution to refugee problem in Africa, whereas in case of Europe, the Dublin and the Schengen agreements, on the other hand, were drafted in order to harmonize European practices and procedures relating to asylum seekers so as to ease the removal of internal borders of European Union. The Central American region, after legally binding instruments approach, there is another important dimension, and that is the non-binding declaration approach. In case of non-binding declaration approach, my dear friends, the Central American region chose to take the path of non-binding declaration because the governmental consensus was lacking in the Organization of American States. Because there has not been any kind of a political will among the Organization of American States. There has been a lack of political will, paucity of political conviction. And that is why they could not come out with a framework of a regional character for protecting refugees in Central American region. Different legal traditions prevail in different parts of this particular region. Latin America believes in the principle of diplomatic asylum, which is not recognized elsewhere. In case of United States of America, being an immigrant country, has a different approach to receiving refugees compared to other organization of American states members. We are also having in 1984 Cartagena Declaration that was thereby a product primarily of the non-governmental process. As we have recently witnessed almost 20 years back or 21 or 22 years back, the efforts of the non-governmental organizations has ultimately incepted a very, very important instruments in the field of what we call of international humanitarian law, that is popularly known as the Ottawa process. And that Ottawa process is basically a result of a convention, or that convention is known as the Ottawa process on a United Nations Convention on landmines. That was primarily a product of the efforts which were invested by the non-governmental organizations that ultimately resulted in the culmination of this full-fledged international convention. Same has been the case of what we call of this Cartagena Declaration, which is in the context of the Latin American states. Therefore, political approach, political will, political understanding, and political conviction constitute a very, very important aspect of any legally binding, non-legally binding, any kind of an understanding which is likely to be brokered at international level. Therefore, my dear friends, Cartagena Declaration was primarily a product of the political conviction. And the entire advocacy was sponsored by the non-governmental organizations. Awareness was created by the non-governmental organizations. Dissemination of information regarding the plight of refugees in the Latin American countries was highlighted by the non-governmental organizations. So it was the contribution of these kinds of organizations, including the civil society institutions in Latin American countries, which ultimately resulted in the adoption of the Cartagena Declaration. Another example of the non-binding instruments is the 1966 Bangkok Principles, my dear friends, concerning the treatment of refugees, and that was adopted by the Asian African Legal Consultative Committee, which is popularly known as ALCO, which is again, my dear friends, an intergovernmental body. We are also having an intergovernmental body in our part of the world, that is the Saarc region. And under this particular, intergovernmental organizations, we have also established an educational institution like South Asian University as an intergovernmental body. So you can very well understand that we need to further develop and encapsulate our anthropological, cultural, political, social, and diversity-based characters of our societies, and we have to evolve on the basis of these elements a South Asian approach to international refugee law. Therefore, ALCO has developed these fundamental principles, which is today known as the Bangkok Principles of 1966. Because of the advisory nature of the ALCO and the divergence among the member countries of Africa, Middle East and Asia, who comprise the ALCO, the Bangkok Principles have had less of an impact, and they remain of value as the only regional refugee document applicable to Asia. Whenever we are going to deliberate, my dear friends, what are the bottlenecks? Why we are not able to develop a South Asian Charter on refugee protection, number one, or why we are not in a position to have an Asian Charter on refugee protection, an Asian Convention on refugee protection, then we should not ignore this Afro-Asian understanding resulted in the Bangkok Principles, sponsored by ALCO. So these documents becomes very, very important as per its application to Asian nation states. However, we have witnessed a kind of an interest in the Bangkok Principles. If you take into account the recent scholarship, you will also find, my dear friends, some kind of a revivalism. Revivalism in the form of, that the scholarship, existing scholarship, again, falling back upon these, fundamental principles known as the Bangkok Principles for the protection of refugees. Therefore, it is the, fundamental duty of the nation states, my dear friends, particularly the nation states of the Global South, Afro-Asian, if we are going to have further classification, because the Global South and some of the Global South nation states have already reached an understanding, they have adopted an understanding in the form of declarations. Non-binding instruments are, there. But there are, nation states hailing from South Asia, hailing from Southeast Asia, hailing from Afro-Asian nation states, they require another kind of what you call, opportunity where they should be in a position to have an understanding, to have an approach which is specific to their regions. And our region is one of such what you call, category. And therefore we must have some kind of a South Asian approach to refugee protection. This is only possible if we are initially going to have a non-binding instruments first in the context of South Asia. How we are going to have this kind of a approach? Definitely this approach would be based on our differences, distinctions, and dichotomies, which ultimately impel South Asian nation states not to exceed 1951 Refugee Convention. Now I take you to another important element as an approach, as an impediment. And on the basis of this impediment, on the basis of this particular, goalpost, which is popularly known as the operational arrangements approach, how we are going to further develop a South Asian approach. And thereafter, I will switch over to another important what we call, understanding. And that understanding is going to appreciate the differences as well as the oppositions. And the points of oppositions I'm going to highlight why the South Asian nation states are not ready to accede to 1951 convention. So if they are going to have some of these oppositions or these points of oppositions, then on the basis of these points, we may further what we call, develop our own understanding, our own, approach, which takes into account entire region specific distinctions, oppositions, and other important points which are likely to be further developed and reflected in that very ensuing approach. Operational arrangements approach has been, my dear friends, to develop regional arrangements related to specific refugee problems, such as the comprehensive plan of action for Indo-Chinese refugees in Southeast Asia, and the International Conference on Central American Refugees. Both agreements, if you take into account both these understandings, then both agreements were reached by the governments concerned together with UNHCR regarding non-standing or long what we call standing refugee problems in these regions of the world. The main purpose was to solve the refugee problems in a comprehensive manner, including, my dear friends, addressing the root causes, providing effective protection to refugees and displaced persons, and achieving durable solutions to their plight. Because they related to specific refugee problems, they did not necessarily establish a regime for dealing with future refugee problems. However, they created precedent for regional cooperation, which bodes well for the future. If you take into account Commonwealth of Independent States Conference, not only tried to resolve existing problems, but also set out to establish principles, procedures, and programs to manage future population movements. As we have seen in the case of what we call of comprehensive plan of action for Indo-Chinese refugees, as well as the Central American Refugees Conference. This kind of a approach, which is known as the operational arrangements approach, which is specifically, my dear friends, an heavily based on cooperation between the international community and countries in the region, because these, nation states have realized that do not have the means to tackle the issues by themselves, and that is why, if you take into account, my dear friends, you will also find that this kind of, on the basis of the analogical deduction, we also come across that the element of international solidarity, element of, international responsibility sharing paradigm has also been incorporated in the global compacts on refugees and migrants in the month of December in 2018. So it is equally important to understand that these elements under all circumstances must be appreciated in totality. That is why, my dear friends, we have to undertake certain important elements which come from the experiences of other nation states. Suppose how to develop South Asian approach towards a regional arrangement. South Asian countries have experienced, my dear friends, a large scale refugee flows from outside the region as well as from within the region. However, these problems have been handled by the governments in an ad hoc manner and on the basis of administrative mechanism and administrative policy. I generally do not like, as a student of international law, as a student of law, I personally feel that there should not be any kind of a policy framework, because policy has always created instability, volatility, and predilections. So policy is not at all in the favor of what we call of, refugee protection. And that is why, if you take into account, none of the countries in the Saarc region have signed the 1951, convention relating to the status of refugees. Nor they have any kind of a, national laws or national legislation, regional instruments specifically designed for the governing or for governing the, refugees in this particular, region. Generally speaking, my dear friends, there has been little movement to develop a legal framework, because accession to human rights instruments and constitutional guarantees, combined with a generous asylum policy and a lenient attitude of the judiciary, have provided some protection to refugees and created a good humanitarian record for this particular, region, that is the Saarc region. However, experience has shown my dear friends, that the protection of refugees has been precarious in the absence of legal principles in South Asia. If you take into account the latest judgment, not judgment but the interim order of the Honorable Supreme Court of India, that is again an indication of this volatility. Therefore, the failure of law to distinguish between refugees and other what we call, foreigners, especially the economic migrants, have also led to, in some cases, inconsistent treatment, while negating across the border treatment among refugee groups, and sometimes detention, even deportation and refoulement of refugees have also been, witnessed. Therefore, in these kind of circumstances, it becomes incumbent upon national governments in this particular region, that is the Saarc region, to understand the requirement and the necessity of a national legislation, a regional what we call mechanism for the protection of refugees. And that is why the South Asian governments have preferred, if you take into account this particular background, which I have narrated before you, then the South Asian governments have preferred to deal with refugees on an ad hoc basis, because it provides from flexibility without which they could not find solutions to sensitive refugee problems affecting regional stability and national security. Most of the refugees in South Asia are from neighboring countries. For example, refugees in the past have also moved from Sri Lanka to India, from Bangladesh to India, from Myanmar to Bangladesh, from Afghanistan to Pakistan and to Iran. As such, the refugee problem is a major factor in bilateral relations between the host and asylum and home countries. Furthermore, because of the ethnic affinities between the host community and the refugees, in many cases, for example, Sri Lankan Tamil refugees in Tamil Nadu, Afghan Pashtuns in Pakistan, or Bhutani refugees of Nepali origin in Nepal, the response to refugee problem has been determined by the domestic politics as well as the foreign policy paradigms in South Asia. And this has created a very, very murky situation. While an ad hoc approach to refugees may have been acceptable in the past for a variety of reasons, a few climate, rather I should say a new environment of cooperation among the states in the Saarc region supports a consideration of developing an approach on refugees based on commonly accepted principles and practices in the Saarc region. And my dear friends, among the factors favoring this approach are multiple. Many factors, many considerations may be held responsible for developing this kind of an approach, as I have already submitted at the very initial stage, that whatever the oppositions we have been witnessing in the approach of the South Asian nation states that resulted in the non-accession of 1951 convention with its additional protocol of 1967, then these points of opposition may constitute or may be considered in future as the foundation of a new South Asian approach to refugee protection. For example, Indian subcontinent, if I am allowed to use such an expression, in a class of the South Asian students, because there are students who do not like this kind of an expression, South Indian subcontinent. Rather, I should say South Asia or South Asian subcontinent will continue to witness, my dear friends, large-scale population movements. Socio-economic factors such as poverty, population growth, environmental degradation, natural disasters, combined with ethno-political conflicts, are uprooting large number of people in this particular region, that is South Asia. Because of the open borders between India, Nepal, and Bhutan, and the difficulty of controlling borders between India and Bangladesh, and India and Sri Lanka, large number of people are on the move, which impacts on the social, cultural, and political relations of the countries of this particular region, and the countries who happen to be what we call at the tri-junctions or having some kind of a land borders or the sea borders. Such issues, my dear friends, may thereby require a longer term comprehensive response, which by their very nature will build upon cooperation and coordination on a regional basis. My dear friends, due to the complex mix of refugees, economic migrants, displaced and stateless persons criteria need to be developed to distinguish different groups and ensure appropriate what we call responses to different groups. Further, in this connection, national legislations may be adequate without a common approach. If the regions, more than one country or more than two countries from South Asia are not in a position to develop, or the nation states hailing from South Asia are not in a position to develop a regional arrangements, then the best alternative that must be cajoled further is the adoption of a national legislation, and that should be an appropriate what we call alternative in the absence of a common approach among all the nation states of South Asia. My dear friends, there may be sufficient commonality of problems. Commonality of problems, commonality of policies, and commonality of practices among the Saarc countries to develop a regional approach. All states in the region are affected by the refugee problem. The problems straddle borders and sometimes, my dear friends, affect more than two states. At the same time, South Asia has a rich humanitarian tradition. This should never be forgotten. All countries in the region have received refugees, and they have sought to find solutions to their refugee problems, and most commonly through voluntary repatriation. Moreover, they share similar legal and administrative systems. If they have adopted some kind of a refugee policy, then all the nation states except Afghanistan in South Asia, majority of the nation states have been transacting their refugee protection businesses on the basis of ad hocism of an administrative character, which is exclusively based on governmental choices, predilections, and preferences. Which particular party, what kind of ideology, with what kind of an ideology a political party has come to power, their policies are basically designed in consonance with those political preferences. So a policy framework has always been there, and the best what we call mischief, or the best what we call lacuna of a policy is its instability. Policy cannot be perennial. It is always volatile. And that has created a lot of problems in addressing the problems of refugees, protection of what we call of a refugees. And therefore, my dear friends, a regional approach may allow South Asia to address its specific what we call concerns on refugee issues. That is why there is a requirement. If we are having the commonality of approach, commonality of practice, then what is the harm to have a common approach at regional level? One of the main complaints of South Asian states about the international refugee instruments is that they are inadequate to cope with the particular problems of this particular region. I can give you an example. In the form of due to the complex mix of reasons which underlie population movements in South Asia, it is sometimes difficult, my dear friends, if not impossible, to apply the international refugee definition. So definition has created a lot of problems. Again, due to part in the absence of compulsory birth registration in the subcontinent, though this practice of birth registration recently started. And even in India, majority of the, people have also started preferring birth registration. Because in the past, non-registration of birth has given rise to statelessness, which are peculiar only to this part of the world. And these are the concerns which could be addressed on a regional basis. Though I have to undertake some other important, steps. Steps in the form of certain important, consultations as well. Because options available to the states in the Saarc region would include accession to the 1951 convention with its additional protocol. Then again, a domestic legislation, that is another important, option that must be what you call, enacted, keeping in mind the specific problems as well as the magnitude of the refugee problem affecting specific countries in the Saarc, region. Then again, my dear friends, a regional declaration which is not binding but would give rise necessary direction to the state what you call, practices. And that is why in the year 2004, the Saarc nation states has come out with a regional what you call, declaration, which is exclusively devoted to the protection of refugees and migratory movements in the Saarc region. And in this particular declaration, you will find a combination of the two important instruments. Though other instruments have also been, the soft laws in the form of, regional declarations have been consulted by the eminent persons groups. I would also be addressing that particular, aspect. But it is important that we require a regional declaration. And that requirement has already been fulfilled in the year 2004. But it is still gathering dust in the corridors of, power. Therefore, a regional approach could improve the prospects for solutions and better cooperation. And some of the important initiatives taken at the Saarc for economic cooperation as well as in other fields have shown a positive political will from states in the region. And the establishment of the South Asian University is such an important, initiative. It is a manifestation of the political will. If we can achieve South Asian University, if we can do wonders in the field of, higher education in the form of, establishment of the South Asian University, then in making legislations, in making and developing a regional approach for the protection of refugees, it is equally important and it is not going to be an uphill task. At least a common minimum understanding must be achieved by the, South Asian nation states for the protection of refugees in our part of the world. And that is why lot of what we call, informal consultation on refugees and migratory movements in South Asia has established, involved, as well as, taken place. And we have achieved a very, very important mechanism for the protection of, of refugees. Because consultation constitutes a very, very important element in having a South Asian approach, and consultation could adopt a non-binding, what we call, understanding in the form of, declaration. But when we have adopted this particular, declaration, and that is a declaration of the 2004, the national governments have not bothered at all to have this kind of a, understanding for the protection of, of refugees. So it is important, my dear friends, that we should what we call, create an understanding of high order, because in South Asia, the word refugee is emotive, evocative, and even powerful due to the sub-continental exceptionalism, which is exclusively based on, Vasudhaiva Kutumbakam. It means the world is one family. There are refugees. My dear friends, in South Asia. But reasons of their displacement may be different from the reasons of displacement in other parts of the world. In South Asia, people have been fleeing hunger, run for their lives, or for freedom from their own governments, freedom from natural disasters, or from man's inhumanity towards man. And today there are millions and millions of people from a variety of national backgrounds on all the what you call continents, populated continents. South Asian region hosts the largest number of refugees in South Asia, particularly India, as well as now Bangladesh. One in every citizen, if you take into account the international calculation, you will find one in every 100 what you call citizens in the world is a refugee or an internally displaced person or an economic migrant. Historically speaking, my dear friends, South Asia has witnessed substantial intra-regional movement and dislocation of regional refugee groups, fleeing ethnic or religious persecution and political instability. Bangladesh, India, Pakistan, and Nepal are countries that receive refugees, while Afghanistan, Bhutan, and Sri Lanka have generated refugees. In all regions, political violence and developmental policies have created huge numbers of internally displaced persons as well as stateless persons. South Asian countries, my dear friends, continues to be an area of major refugee flows. Against what we call background of the burgeoning socio-economic and ethnic tensions, the issues relating to these population movements are likely to become more complex in the future. And therefore, apart from the political and security considerations, receiving states in South Asia have become increasingly wary of the adverse economic, social, and environmental consequences of accompanying refugee flows. In addition, my dear friends, the ever more restrictive asylum policies of a growing number of Western countries have dampened the interest of at least some countries in the developing world in upholding the ideals of international refugee protection and acceding to international refugee instruments. This has also created very, very important what we call problems. Then in these circumstances, if you take into account how to frame law on refugees, law on refugee protection, then I have identified, my dear friends, four important mechanisms. One is globalism. Second one is regionalism. Third one is bilateralism. And the fourth one is nationalism. So I have identified as many as four important elements of addressing refugee problems in South Asia or developing a regional approach towards refugee protection in South Asia. If you take into account the first one, the globalism or by globalism, I mean, my dear friends, acceding to international refugee instruments. Then the second one is the regionalism. And I mean by regionalism is developing a regional instrument for South Asia. Bilateralism is the third important element which I have framed for enacting a legal understanding, a legal instrument, and I mean entering into bilateral treaty arrangements, as we have witnessed in 1993. A bilateral agreement has been concluded between Afghanistan and Pakistan for the repatriation of Afghan refugees in Pakistan back to their country of origin, that is Afghanistan. So bilateralism may also be one of the solutions in South Asia. Then the nationalism. By nationalism, I mean, my dear friends, enacting national what we call legislation. Because the basic instruments of international refugee protections are the 1951 Convention. Regional conventions and declarations have since been adopted, draw heavily on this particular convention, or opposition to this particular convention, by taking into consideration the local requirements, the region specific what we call concerns, and they have been encapsulated in the form of what we call an approach. Therefore, or rather I should say, so far no South Asian state has expressed interest in acceding to this international convention, which is known as 1951 UN Refugee Convention. Many reasons, my dear friends, have been put forward to explain the opposition of the South Asian nation states, why the South Asian nation states have not become or not acceded to 1951 Convention. The perception that the 1951 Convention among the what we call South Asian nation state is, there is a perception that 1951 Convention is a Cold War instrument tilted in favor of political refugees and therefore inappropriate for the South Asian situations where the mass exodus of refugees is caused mainly by generalized conflict. Another important argument that is generally offered by the South Asian nation states, that the bureaucratic wariness of the perceived interventionist what we call activities of the United Nations and other international agencies would have their say in the internal what we call matters of the South Asian nation states. There is again another important opposition in the form of apprehension of policymakers that the consequences of signing 1951 Convention might entail obligations that they may not be able to prepare, or there would not be any kind of a possibility to meet the terms of resource mobilization for the protection of refugees in South Asia. So that is another important argument which is offered by the South Asian nation states for their not acceding to 1951 Convention. Again, there is a perception that the convention is being abused by the refugee groups in the developed countries who are collecting funds for terrorist activities in their countries of origin. And to some extent, my dear friends, I believe that, and on some other occasions, we have already what we call deliberated the radicalization drives undertaken by the refugees or individual refugees as well as the collectivity of refugees, and how they have abused entire understanding of migration and the refugee movement. So radicalization has also given some kind of a understanding, and that understanding has given rise to opposition. Another important opposition is the belief that as a region, South Asia has been generous to refugees, and that accession to convention would not necessarily improve the conditions of refugees in South Asia, because historically speaking, South Asia has always been a very, very hospitable region, and it has always, since antiquity, has accommodated refugees. Because on the basis of the South Asian exceptionalism, which I have been talking, which is popularly known as the Vasudhaiva Kutumbakam, it means the world is one family, principle, it has always been extending protection and shelter and refuge to migrants, to refugees, to stateless people. Therefore, South Asian nation states also advance another important argument, and that is the derogation by developed countries of the international refugee protection principles. Because in the persons of 1951 UN Convention, my dear friends, but it has become a fashion among the European nation states, among the Western or the global North nation states, at any moment on the basis of their political will, on the basis of their understanding, they can discard any fundamental principle from observing so far refugee protection is concerned. So law of derogation is generally practiced and invoked by the global northern nation states, and they are not humanizing the law of derogation. Then there is another important what we call argument, and that is the possibility of economic migrants benefiting from the convention principles. It means the political refugees as well as the humanitarian what we call refugees, they are not going to be protected or benefited under the 1951 convention. Rather, the economic migrants going to have a better deal in terms of benefits, in terms of refugee status, in terms of a range of rights which they may enjoy. So far, the convention principles are involved. Another important approach, if you take into account the second important understanding which I have offered, and that is regionalism. On the basis of regionalism, how to frame a regional what we call instrument. Regional instruments constitute another important structure of the refugee protection, or may what we call evolve a very, very important structure of refugee protection. We should take experience, we should benefit from the experiences of other regions. Like OAU Convention of 1969 reflected the frame of minds of the political leadership of a continent engaged in anti-colonial movements. OAU Convention broadened the scope of the definition of refugees to include those fleeing apartheid, colonial oppression, and generalized violence, and emphasized voluntary repatriation as a solution to refugee problems in entire Africa continent. In Europe, we have witnessed the Schengen arrangements of 1985 and the Dublin arrangement of 1990. And these arrangements were directed to develop a common strategy to deal with asylum seekers within the European continent. Therefore, to address their own regional needs, even the Latin American states opted for a non-binding Cartagena Declaration in 1984. Declaration was, my dear friends, were formalized by the non-governmental sectors, as I have already submitted. Yet the governments of Latin American region tend to follow it as a matter of what we call of a uniform policy, not what we call national policy, not as a part of the national policy. Rather, they have adopted a regional policy. At least there is something in black and white in the form of Cartagena Declaration, and that is why they are in a position to follow this regional common understanding for the protection of refugees in their region. Therefore, the Cartagena Declaration further broadened the scope of the refugee definition to include foreign aggression, internal conflicts, and those fleeing massive violations of human rights. The last important element, it is not the last, but in terms of understanding, I am using this word. Otherwise, you may also have, in the light of the cumulative instruments, whatever the instruments have been made available by the international wisdom of the nation states, under the auspices of the most important multilateral organizations, that is United Nations organizations, we have come across to understand how to deal with the problems of refugees, and therefore we have adopted these global compacts. So whatever the instruments whether the binding instruments, legally binding instruments, or the non-binding, what you call, instruments, soft laws and the hard laws of an international character are available at international level. We should try to, what you call, develop a regional, what you call, approach in South Asia. And that is why, my dear friends, what we have, witnessed when there is a question of what you call of a national legislation, that we must have a national legislation. Given the realities of South Asia, my dear friends, efforts should be geared towards developing comprehensive national laws which uphold the universal principles of international refugee protection while taking into account the distinctive traits of this particular region, that is South Asia. And my dear friends, initially in the second half of the 90s, we have witnessed some initiatives at an unofficial level towards developing a regional refugee protection regime, or a regional refugee, or the South Asian approach towards refugee protection in South Asia. Now I am going to give you a very, very historical background how in the year 2004 this particular region was able to develop a regional approach towards refugee protection. The constitution of eminent persons group in 1994. This eminent persons group for South Asia was constituted and contemplated by the UNHCR. And it was the most important step that was initiated by the UNHCR. In the very first meeting of this EPG, eminent persons group, then EPG agreed to hold annual regional consultations to promote public awareness and identify mechanisms and strategies for moving towards accession, or alternatively formulating a regional instruments adapting the convention to the needs of the South Asian region. The Colombo consultations of 1995 underscored the need for a South Asian regional legal regime for refugees and a common declaration reconfirming the validity and relevance of the definitions contained in the international refugee law instruments, as well as the regional instruments like 1969 OAU Convention and 1984 Cartagena Declaration. My dear friends, the principal focus was on the development of a regional normative framework that would address the needs of the refugees, stateless persons, and IDPs. It was at the New Delhi consultations that took place in 1996. There was a strategic shift in favor of a model law for refugees that would be applicable at the national level. My dear friends, consultation also emphasized the requirement for better public awareness building about refugees and IDPs, and concluded that the national legislations would permit a better understanding of the common principles, practices, and policies. And these commonalities in the principles, practices, and policies were also identified, which eventually enabled this particular group, that is the eminent persons groups, to have a regional legal framework. But my dear friends, it was the Dhaka consultation of eminent persons groups in November 1997 that a model national law was approved. This model national law is the first step in the process of building a regional consensus on preventing, managing, and solving the problems accompanying refugee flows in a comprehensive and a very, very across the board treatment that must be meted out, and that too with a human rights based approach. The purpose of this law, I mean the model law, is to establish a procedure for granting refugee status to asylum seekers, to guarantee them fair treatment, and to establish the requisite machinery for its operationalization, execution, implementation. The model law incorporated the ethnic identity in its categorizations of people who would qualify to gain refugee status, and in the note enables and establishes that the membership of a particular social group will also include gender-based persecution, which was absent in 1951 UN Convention on Refugees definition. In this particular context, the model law provided a comprehensive definition suitable to the entire what we call South Asian region. Model law, my dear friends, affirmed the principle of non-refoulement and laid down rules for application of refugee status. This model law also provided for setting up an implementing agency, and that is likely to be headed by a refugee commissioner and an appellate body, and that was known as and incorporated in this model law as refugee committee. And the rules for determination of the refugee status were also contemplated in the light of what we call the handbook that has been prepared by the UNHCR for the determination of refugee status, which I have already emailed you when we were discussing under the week 4, the determination of refugee status. Model law, my dear friends, is the part of 2004 declaration. And this particular model law, as a part of 2004 Declaration on Refugees, explicitly sets out the rights and duties of refugees and provides for appropriate procedures in the case of mass influx. I will also share a very, very important link, my dear friends. A link of my own article, though I should not share. Generally, I try to avoid what I have written on refugees. But I will share this particular link. An article of mine was published by the Harvard International Law Journal, and I will share this article. Just a moment. Yes, there was some connectivity issue. This model law, accomplished by the eminent persons groups, explicitly sets out the rights and duties of refugees and provided for appropriate procedure in case of mass influx. An important safeguard for those who enter illegally has been provided, and in order to ensure the voluntary nature of repatriation, the model law makes it necessary that refugees express their wishes in writing or through other appropriate mechanism. Model law also provided, my dear friends, a basic framework by embodying procedures for the determination of the refugee status, including legal assistance and interpreters facilities and interpreters services that must also be made available to those refugees who are not in a position to understand the lingual implications and the language of the host countries. Then there is another important model. I mean, in terms of regionalizing refugee protection in South Asia, There is another important, alternative, that is accession to other international instruments. When we are talking of accession to other international instruments, then other international instruments that have major relevance for the protection of refugees and IDPs should not be forgotten. Civil society institutions may urge states which are not signatories to these conventions and covenants to accede to these instruments, and also press those states that have acceded but have not made enabling national legislations to do so. All countries of South Asia, my dear friends, have acceded to the Convention for the Elimination of Discrimination Against Women, UN Convention on Child Rights, and the International Convention for Elimination of All Forms of Racial Discrimination. Accession to these conventions obliges states to uphold and protect the rights of women, children, and racial and ethnic minorities in large influx or exodus situations. My dear friends, South Asian states should also consider signing the convention relating to the status of stateless persons and reduction of stateless persons. But the South Asian nation states find themselves in a kind of a dilemma. In South Asia, there are 4 major dilemmas in the Refugee Convention, or with regard to Refugee Convention. Number 1 dilemma of the South Asian nation states is relating to the definition that has been provided under 1951 UN Convention relating to the status of refugees. Second important dilemma is relating to, my dear friends, is material assistance. Third dilemma is shared responsibilities and unraveling consensus. Because of these, fourfold dilemmas, South Asian nation states do not find themselves in a comfortable situation in observing standards of international law. But ever since, the international community of nation states have already acceded to the non-binding principles which have been contemplated in the Global Compacts on Refugees and Migrants of the 2018, and majority of the South Asian nation states have already acceded to these non-binding instruments, then some of the dilemmatic concerns have already been wiped out. Therefore, what remains to be understood is that it is the definition and the material, what we call assistance, to a very limited extent. Because in the global compacts, as I have already submitted regarding global compacts, Global Compact on Refugees has also further what we call contemplated a CRRF mechanism, that is Comprehensive Refugee Response Framework. And another important what we call instrument, another important element of this framework happens to be, my dear friends, international solidarity. So these 2 important elements of this Global Compact of the 2018 really minimizes the concerns of South Asian nation states, because Refugee Convention has been the point of what we call of fierce contention for the developed and developing nation states. 1951 Convention has become the bone of contention between global North and global South nation states. Developed countries are tendering for a right-based approach, while developing countries, on the other hand, have been voicing their equitable approach. One is the right-based approach, another one is the equitable approach, sponsored by the global South nation states. Some prominent scholars, my dear friends, feel that before acceding to 1951 Refugee Convention with its additional protocol of 1967, South Asian states should go ahead for adoption of a right-based national legal framework to deal with asylum and refugee issues. At the same time, some scholars recommended that the states in South Asia should ratify Refugee Convention and its protocol without further delay. And I have also, witnessed, let me name Professor B.S. Chimney, who has always advocated opposition to 1951 Refugee Convention definition. And after opposing almost for 40 years, recently he has also changed his position. Particularly after the conclusion of the global compacts in 2018, and I think either in 2017 or in 2018, Professor Chimney has also went back from his approach towards 1951 Refugee Convention. And now he is of the view, and he is advocating the South Asian nation states, or very comprehensively, all the global South nation states must accede to the Refugee Convention definition provided in 1951 Convention. As compared to many developed countries of the world who have adopted very strict entry procedures, states under Saarc grouping have adopted rather soft policies on entry and stay of asylum seekers and refugees. For example, I can give the example of the Bangladesh, India, Nepal, and Pakistan. The states have also adopted and provided what you call, shelter and other humanitarian relief to different groups fleeing persecution, who are victims of the forced migrations, including of natural disasters, people fleeing generalized violence, abuse of human rights by state and non-state actors, communal and ethnic strife, and the victims of man-made ecological disasters. All have been provided shelter by these, four nation states in this part of the world, that is, South Asia. However, in some cases, my dear friends, there are reported incidents of the refoulement pushing back to the, territories where lives of the individuals were at risk. And one of the most important, institutional discrimination is, there, and that institutional discrimination is nothing but I'm talking of the entering order of the Honorable Supreme Court of India regarding deportation of the Rohingya refugees. So, my dear friends, if you take into account the causes, what are the, causes, particularly with regard to the refugee flows in South Asia? One of the features of the refugee, situations in South Asia is that mass transnational movement of people characterizes them. Then there are, certain important questions that come to my mind, and that is, what are the causes of refugee flows in this particular, region? Why have the states in South Asia failed to address this human suffering of a very vast magnitude? Does it indicate a failure of the state system in this particular region, that is South Asia, to develop an inclusive polity based on pluralism, that people belonging to all backgrounds are given a socio-political and economic space in their political system? So these are some of the important and very, very tricky questions. If you take into account the entire canvas of causes of the refugee flows in South Asia, you will find, my dear friends, that there are causes which are human generated. There are causes which are nature generated. There are what we call, causes which are manufactured, causes. And we have to provide a diagnosis of these what we call, causes. What are the human generated causes? Fight for political independence, identity, racial and religious equality within the institutional and structural responses of the Saarc states. That is one what we call, human generated cause. Another one is human rights violations, including social discrimination and de-citizenizing. Economic alienation, including poverty, forced colonization, landlessness, religious persecution, cultural discrimination, population transfer, armed conflicts, generalized violence against certain minority groups in South Asia, ethnic groups, caste violence. These are the human generated causes. Then we are also having nature generated, causes. Environmental dislocation, construction of what we call of high dam projects, deforestation, desertification, natural what we call, disasters, ozone layer depletion, rising sea levels, climate change induced displacement, dislocation, climate change migration. These are, my dear friends, nature generated causes. Then there are, manufactured what we call, causes. Manufactured minority complex of majority communities. Border disputes between countries. Armed race in South Asia. Geopolitical considerations of superiority. Forced land colonization in the name of what you call, land reforms. Lack of proper citizenship laws. Cultural suppression. Refusal to sign international human rights instruments. Despite the fact on many occasions South Asian nation states have submitted their common understandings regarding their willingness to ratify, but they have not submitted their instrument of ratifications to the Secretary General on many international human rights instruments. Like, for example, I can give you an example of Torture Convention of 1984. India has signed it, but it has not ratified it. Then what is the diagnosis? How to identify? What kind of identification, and what is the result of this identification? My dear friends, this should not be forgotten that the state is the main actor in generating refugees in South Asia as in other parts of the world. The upsurge in refugee flow in the post-Cold War era was primarily caused by the states induced refugee factors, which I call SIRF, SIRF, states induced refugee factors. I can give you examples of SIRF. State repression for political or ethnic reasons, that is one reason. Failure of state to provide economic, social, and environmental sense of security to the people, that is another important reason. Even the global pandemic has also made some refugees. It has also, created a mask, what we call, internal movement of people. I mean, the economic migrants who haven't crossed international borders, but in some situations, there have been, economic migrants who have crossed international, borders. So even the human mobility has been what we call, caused by the global pandemic, where there has been a lot of concentration of global, pandemic. People have started living those, places. People are living Bombay. People are living, metropolitan cities like, Delhi, and they are going to the rural areas within the what we call, India. Same has been happening in Pakistan as well as in other, jurisdictions of, South Asia. Therefore, government in, such situations is not in a position. And this global pandemic has also, given us a new thinking, particularly to the educated class and to some extent even to the less educated class of the, people. It has really generated an avidity among the people that governments, national governments must revisit their priorities. They must recalibrate their institutional development. It has global pandemic, the second wave of the global pandemic, re-established, my dear friends, what should be the, priorities of the global governance, regional governance, and national governance. It should be the humanity that should be the uppermost and topmost consideration in the priority list of the governmental agencies. And what we have been, witnessing, because sometimes on 2 or 3 occasions, I have also felt a sense of depression. And that is why I have started almost a year, I have abandoned television. I simply read now. Because the visual content is very horrendous and heart-wrenching. It does not mean that I should run away from the stark realities of global pandemic. But my heart is not in a position to bear all these, sufferings and pains. Recently, almost 15 or 16 days ago, I received a video. And immediately after, seeing that very video, I started vomiting. And thereafter, I'm not in a position. I immediately, whenever I receive any, video, I delete it. But I have been, reading each and every aspect of the global pandemic. The situation is very, very horrendous. We should try to understand. I'm not at all discouraging you. Rather, I'm preparing you because of your age. You happen to be in the prime of your youth. It's a prime youth. I am having a different stage of my age. And already I have become a depository of so many diseases. So, global pandemic has also generated a new humanity that happens to be in transition, in destination, in transmigration, in migration. And we should also witness and assess the impact of the global pandemic on refugee camps, on refugee, what we call, populations. Because the post-colonial state formation, my dear friends, particularly the post-colonial formation process in South Asia, that remains at the one of the refugee generations in this particular region. Population movements from India to Pakistan immediately after the or in the aftermath of the partition of the subcontinent is one of the biggest non-displacements in the human history. This partition of India has its roots in the state formation process of the two separate dominions of India and Pakistan. It is altogether a different story that we have received another important country on the world political map in the year 1971, which is today known as Bangladesh. And formation of state process or formation of Bangladesh state process has generated a further what you call influx of Chakma refugees in India from Bangladesh that ultimately, follows the firstly assimilationist and later exclusionist, approach or policy of the Bangladeshi government in its effort to build an Islamic state based on the culture of the mainstream Bengalis. Initial stage I am talking of. Captai Dan Austies are a victim of the economic phase of the nation building process of Bangladesh because Chakma refugees in India, they primarily got displaced from the Chittagong Hill Tract in Bangladesh, and because of the governmental cynical approach, and some other circumstances, they felt compelled to move out of Bangladesh and crossed an international border between Bangladesh and India and crossed over in India. There is another important policy, that is the revivalistic cultural nationalism based on the culture of Drupka's manifested its one nation, one people policy has rendered over 100,000 southern Bhutanese refugees. Nation building is another important factor of generating a lot of refugees. And I can give you an example of Sri Lanka, where we have witnessed a nation building process based on the culture of a majority Sinhalese is the central reason behind the political bedlam, my dear friends, that the state and subsequent refugee influx has also taken place in India. Majority of the Tamil refugees were received by the government of India, though some of the, from the urban centers, rich Tamils moved out of, Sri Lanka, and they took shelter in Great Britain. Some less fortunate, Sri Lankan Tamils were also what we call, given shelter by the government of Pakistan in South Asia. Very few people moved to Iran. And some of the what we call, Tamil refugees have also taken refuge in Germany. So these influxes, exoduses of refugees have generated a lot of problems for South Asian nation states because of the absence of a regional approach, because of the absence of a regional mechanism for the protection of refugees, and in the absence of national legislations. Because legislations, as a student of jurisprudence, all of you are well acquainted that the legislation is considered to be the strongest source of law. It is the beauty of a legislation that, stabilizes any kind of what you call, policy framework, any kind of a policy approach, or any kind of a, political differences. Everything, when we are having a legislation, then legislation primarily creates uniformity of treatment, uniformity of approach. It is ubiquitous and very potent instrument to stabilize and address these kind of situations of refugees. And unfortunately, we do not have any national legislation in South Asia. Now I take you to another important engagement, and in this particular engagement, we would be discussing state practices in South Asia and how in these practices we would try to identify a 12 paradigm in assessing the entire situation of refugee protection in South Asia. So my dear friends, tomorrow I will take up this particular aspect of our engagement. If you have any questions as of now, you're most welcome. So thank you very much. Tomorrow we will take up this particular aspect. Thanks a lot.
Thank you, sir.
You're welcome. You're welcome.
Thank you, sir.
You're welcome, brother. You too, Imran Bhai. Thanks a lot for your concern. I am in prayer for all of you. Please stay blessed and healthy. Thanks.